to revive Mr. Floyd what they reported based on their observations.
What the firefighters saw when they arrived, the symptoms they saw, whether the person was in medical distress, what techniques they thought were appropriate to intervene. All the things that I said for the off-duty firefighter I think apply equally to the other one. It's just observations of what they saw, what attempts were made of revival or resuscitation. I think it's the same line as drawn as for the off-duty firefighter. Okay?
Very well, Your Honor.
Thank you. Mr. Nelson.
Your Honor, I think we could probably quickly dispatch of number 25 and 31 as well. 25 being exclusion of any reference to Mr. Chauvin's invocation of his Fifth Amendment rights. I had a brief chat with Mr. Frank. Just for point of clarification, we are not seeking to suppress any statements that were made or that were captured on body camera footage. We agree that that's admissible, and in fact we've repeatedly stipulated or offered to stipulate to the admissibility of the body-worn cameras from the incident. Likewise, other officers capture conversations and their body cameras. For example, a sergeant responds, asks what happened. It's non-testimonial. We're stipulating that that all comes in. Ultimately, when this turns to a critical incident, however, Mr. Chauvin is brought to room 100 of the City Hall, which is the standard practice in critical incidents here in Minneapolis, and is afforded an opportunity to consult with a lawyer at that time. The lawyer who responded, they didn't make a statement. And I believe, ultimately, we are in agreement that there would be no reference to the invocation of the Fifth Amendment rights at that point beyond. Anything that happened before that's captured on body camera, we agree is admissible.
Mr. Frank, sounds like we're in agreement.
Yeah, with our understanding that that is the sole basis of this motion, we would agree that the council decision to not give a statement is off limits.
So you're saying that you could somehow elicit pre-custody that he did not give a statement?
Well, there are pre-custody statements and lack of statements that would not be covered by the Fifth Amendment, correct?
I think it's always complicated with a peace officer in this situation with the castigar and garrity and the statutory protections. So it's not like a civilian on pre-arrest silence. There's all these other statutes that protect them, and has everybody thought about that?
Well, I would say not fully, Your Honor, because I'm not sure of the extent that those cases would apply to the very situations that Mr. Nelson was talking about. So
Ultimately, Your Honor, the prior to him being brought down to room 100, before this was deemed a critical incident, everything is captured, literally everything is captured on one body camera or another. I don't believe that those constitute garrity statements. They're not forced statements. They're not being, he's talking with Officer King or he's talking with Officer Tao at the scene. No authority figure from the police department is compelling him to make those statements. I don't think garrity applies in that context. Again, I agree all of that is within bounds, anything that is or isn't said. But in terms of saying, once he gets to room 100 and a lawyer is afforded to him and a lawyer counsels him, that's the basis of the motion. I think it would be improper, for example, if the state says, well, Mr. Chauvin didn't make a statement to his sergeant in that instance. I think that would be improper. And also, in this situation, statements were made. He was standing there right next to the other officers who were involved when they gave the public safety kind of statement about what happened. And so again, I think that's all admissible. I would agree that that's all admissible, but an inference that his silence in that circumstance would not be proper. I mean,